Hey guys, so Brooks gets his appeal, he gets his free lawyer, but what happens if that lawyer reviews the record, goes through it, and can't find any good faith basis for appeal? Just any basis would be frivolous. Some people have asked, does he get a continuous stream of lawyers? Is he going to fire this lawyer and move on at the last minute? How can he bring these crazy arguments up to the court? It's just wasting everybody's time. So let's look at that. So the attorney who is appointed is Brooks' lawyer, but that attorney is also considered an officer of the court, as attorneys are. And at the appellate level, you can't bring a frivolous argument, one that you know is frivolous. You're subject to sanction for that. So let's say the lawyer looks through the whole transcript, can't find that Judge Darrell made any error in the jury selection or how she handled the trial or venue. Some of the things we've looked at, they would probably be pointless grounds for appeal. And the lawyer agrees with that and says, I can't find an argument that could even possibly win. Not a weak argument that might win, but it just can't win on these arguments. So as he goes and he sits down with Darrell Brooks and tells him the bad news. Then Darrell Brooks said, well, that's not a problem, bro, because during the trial, as you'll notice, I got a tacit agreement from the judge. The judge never addressed subject matter jurisdiction. She never was able to get jurisdiction over me because I didn't consent to the use of that name. The fringe on the flag was slightly wrong. So we've got some serious, and that's just a start. The state of Wisconsin didn't actually show up as a plaintiff in this lawsuit. So there's so many great grounds for appeal here. We'll certainly get it thrown out. So not a problem with these old stupid ways of appealing like jury selection or evidence or things. If those are weak, I got you covered. Then the lawyer says, well, that's all fantastic. That's a great list. The only problem with it is it's all insane garbage. And I can't put, with my law license on the line, my signature next to those things and put them up in court. So we've got a problem. How does the law in Wisconsin deal with it? It's a little thing called a no merit report. So if the lawyer can't find any good faith basis to move forward with the appeal, they're supposed to proceed under this Rule 809.32, which involves a no merit report. They sit down with the client, the disgusting murderer. Even if they think they're a disgusting murderer, they still need to tell them their options, and they have three under the statute. The first is the attorney can file a no merit report to the court. So in this scenario, the attorney would file a report to the court that says, I reviewed all the relevant record and I find these are the things that potentially could support an appeal. But for these reasons, I think they would not have merit. They would be frivolous, and I can't in good faith present these arguments to the court because this is an appointed attorney. So the court can then look at that and see, did they think the attorney missed something big here or whatever? And if they don't, they would approve this no merit order and let the attorney free of further obligation and also confirm the judgment of the lower court. So the conviction would just stand. So that's option A. The attorney files the no merit report. And given that the likely consequence of that is Brooks stays in jail, do you think he agrees with that? Yeah, no, probably not. The next scenario is the attorney can close his file without an appeal. So then that would involve Brooks going, yeah, you're right. I was wrong this whole way. I don't want to waste anybody's time. That's not who I am. So let's just shut this thing down and I don't have an appeal. Thanks for your effort. Does that sound like Darrell Brooks? Yeah, I don't think so either. The third is the attorney can close the file and the person proceeds pro se, pro per, propane, whatever Brooks thinks he is at that moment, or they can get an attorney at their own expense. They don't get another state paid attorney. So this one, I could see Brooks doing. It says, well, you can't figure it out because you're too stupid. I'll just do it on my own. That's, to me, the likely outcome if this were to happen. The final is the person just doesn't cooperate at all. I don't consent to a no merit report, and I don't consent to having to do this by myself. You need to do it. This is Burger King. I have it my way. You do what I say. If that happens, the attorney can still file and is supposed to file the no merit report. Now, the client can, at that point, file some kind of rebuttal to it, and there can be an argument back and forth, but the attorney's not stuck there. They do not have to proceed with this frivolous claim, even if the client demands it. So they just file the no merit report. Now, it's unlikely that the attorney is going to conclude that there's no arguable basis for any ground for appeal under the law at all, because most lawyers can come up with some kind of argument, but it can happen. And if the attorney decides this is frivolous, then this is the procedure that gets followed. They get to get out of this case. They can either file a report with the court or turn it over to Brooks, basically. And they do not have to prosecute Brooks' lunatic claims about the flag and tacit agreements and things like that. They don't have to do that. As an officer of the court, they're not supposed to do that. They're only supposed to advance arguments that have some legal basis to them. That's it. And if you can't do that, you shouldn't move forward with the appeal. And if the attorney refuses to move forward with the appeal on that basis and the court agrees with it, then Brooks is left to either do the appeal himself or to hire his own lawyer or just to give up on it. So anyway, I hope this answers the interesting question of what happens to the lawyer in this role. Is he just trapped in? Is he an unlucky soul or whatever, and there's no way he can get out of it? No, he can analyze the case, look at it, and if he completely agrees with many of the commenters that there's no basis in law or fact for an appeal, then this process exists to tell the court that and to end your role in the case. Brooks has not filed his appeal yet. His lawyer probably doesn't even have all the information, just has some of it. It takes a long time to go through it. So we won't even know if Brooks is going to allege improper jury or venue or anything else until they actually do the appeal, or if the attorney might come to the conclusion there is no appeal. Still think that's doubtful, but I thought you'd like to see that there is a way that a good faith attorney can get out of this if there's no basis for an appeal and not string the court along with frivolous arguments. Thanks, bye.